and December 3rd, 2020, a 24-day time period, 5 children went to local hospitals, and they were all diagnosed with acute liver failure.
Let's go now over to page 14. Christopher Wren versus Affinity Lifestyle. And when everyone's set up, we'll take appearances.
Your Honor, Kemp for plaintiffs.
Eric Pepperman also for plaintiffs, for the Wren plaintiffs.
And in the courtroom?
Ariana Reese, carrier, thank you.
Thank you.
Good morning, Your Honor. Teddy Parker. I'm just coming in for plaintiff Kaveh, K-A-V-E-H, Alpha, my association, probably today, Your Honor.
Thank you. And for the defendants, please, in order, please.
Each Life for Nevada Beverage Company.
Thank you.
Morning, John for Speedy Mart.
Thank you.
Spurlock, Wholesale.
Thank you. All right. So, plaintiff, it's your motion.
Good morning, Your Honor.
I'm sorry to interrupt, Your Honor. Jonathan Fountain on behalf of defendant NSF International.
Are there any other appearances before I hear from Mr. Kemp?
Yeah, Howard Russell on behalf of defendant Costco Wholesale and also Noushan. Noureddini is on the call. She has submitted her pro hoc admission. We have a motion pending on that. If the court will allow her to argue, if there's no objection by counsel, there's been no opposition to her motion, we appreciate it, but we'll defer to the court on which one of us appears and argues.
Good morning.
Let's take all these appearances, then we'll deal with the pro hoc issue.
Thank you.
Good morning, Lorene Frister for defendant Cahey Distributors of Nevada. We are a party in one of the coordinated cases, and we're just observing today.
Thank you.
Morning, Your Honor. Scott Rasmussen on behalf of Hanna Instruments.
Okay.
Good morning, Your
Honor. Elizabeth Lowell on behalf of Milwaukee Instruments.
Other appearances?
Good morning, Your Honor. Joel Odou on behalf of AffinityLifestyles.com Inc. and Real Water Inc. We have filed an opposition and will be responding today. Thank you.
Thank you. Any other appearances? Is the plaintiff going to have any objection to the pro hoc or allowing argument?
No, Your Honor.
All right.
Your Honor, one more. I apologize. This is Lorene Frister for Cahey Distributors again. I also have Caitlin Zaff, who has pro hoc in.
Very good. All right. Does that now exhaust the appearances? All right. So there's no objection to the pro hoc, so that the argument may be argued today, and a motion, or sorry, the order can be submitted to the inbox for the pro hoc. Now, Mr. Kemp, it's your motion.
Your Honor, this is our motion to consolidate, and let me explain first who we are trying to consolidate. What happened here is between the time period November 10th, 2020 and December 3rd, 2020, a 24-day time period, 5 children went to local hospitals, and they were all diagnosed with acute liver failure. They were sent by emergency jet transports from the hospitals here to a hospital in Salt Lake City that specializes in liver transplants for children. And that would be the Children's Primary Care Hospital in Salt Lake City. Those 5 children were the Wren child, Carrier child, the 2 Williams twins, and the Morales child. The Wren child is in the first filed case. The Carrier child is in the second filed case that's subject to the consolidation motion. And the other 3 children are in the third filed case. The children get to the hospital. They're treated all by the same doctor, which is Dr. Stephen Guthrie, who's a specialist in liver injury with regard to children. The intent when they were sent there was that they would all have liver transplants. They drank the good water on the airplane and the good hospital water, and their condition started to improve. So they decided not to do liver transplants on any of them. But in any event, as a result of seeing 5 children in a 24-day period come from the same locality, all with the same liver injury, Dr. Guthrie called Southern Nevada Health District and informed them that he'd never seen anything like this. So many children in so short period of time with the exact same injury. So the Southern Nevada Health District launched an investigation. They canvassed all the families. They asked them what they drank and ate. And the one thing they all had in common was real water. They all consumed real water. They've all filed suit now. After the health district found the potential cause, there was a comprehensive investigation by the CDC and the Southern Nevada Health District. They've issued a report saying that the 5 children's cases were caused by real water and a number of other cases. And so we think these cases should be consolidated because they're pretty much the same case. So the defendant's counter argument, and of course the question is whether it's a common issue of fact and law. Let's start with
How
facts.
do you link up Cava or Cave?
Cave is another baby who we filed with the baby cases. She was not one of the 5 that went up to Salt Lake City. She was treated in 2018. But discovery has revealed that we have the exact same manufacturing procedure during the entire time period that real water was made. And in particular, the FDA did testing on what they call the real water concentrate. That was the secret sauce they put in this to make it what it was. And in the concentrate, they found hydrazine, which is a rocket fuel. This is the FDA's testing. Since that time, the defendants have done their own testing, and they tested 7 different bottles, and they also found hydrazine, the rocket fuel, in there. So I don't think there's really a big dispute about what caused the injury for the children. Some of the other cases, the adult cases, they're all arguing, oh, well, it's not the rocket fuel. It's because he drank a beer at a high school party. They have other alternative causes on those cases. But the children's cases, there's really no viable alternative cause, I would submit. But anyway, the Cave case, the baby there, the exact same situation, Your Honor, drank the exact same substance, had the same injury. That baby was not flown to Children's Primary Hospital in Salt Lake City for the liver transplant. That baby was flown to a hospital in Denver. This name eludes me now. But it's the exact same situation. So their opposition says, first of all, that there's different questions of fact. I don't see any different questions of fact. Like I already said, it's the exact same manufacturing facility during the entire time period. It's the exact same toxic substance, the hydrazine, that's alleged to be the cause. So then they say, oh, well, the plaintiffs haven't filed their initial fact sheets, which is what Special Master Hale calls his consolidated interrogatories and request for production. All the plaintiffs have filed the fact sheets with the exception of Mr. Morales. At this point, Mr. Morales, we're getting his in. He's in another state now, so he's hard to deal with, but we will get that in, Your Honor. So what is left to do to prepare the cases? There's really not that much left to do because we have the first case, the Gallagher case, set down for trial in front of Judge Williams on July 31st. In that case, we filed expert reports, and we're getting ready to take expert depositions starting next week. So there's approximately, I think, 30 experts in that case, 28. Out of all those experts, most of them are going to repeat their reports for this case. In other words, the hydrazine expert is just we're going to submit the exact same report, and Judge Hale's order, and we talked about it yesterday at the special master hearing, there won't be repeat expert depositions. So in this case, the only need for expert depositions will be the causation experts. We have 2. They probably have 4. So there will be causation experts in this case. But I mean, we're talking about taking depositions of 10 plaintiffs, and the depositions have been going, the plaintiff depositions have been going approximately 1.5 to 2 hours each. So if you really had to do it, you could do them in 2 days. And I'm not suggesting we do that, but I'm saying there's plenty of time between now and next year to take those depositions. And so we have plaintiff depositions and 5 causation depositions in cases ready for trial. So I don't really see a legitimate concern there that we can't get it done. They say, oh, well, there's different issues of law. The issues of law here are extremely limited because assuming for the sake of argument that real water sold an adulterated product, a premium drinking water that actually had rocket fuel in it, assuming for the sake of argument that they sold that and that caused injury to a consumer, the distributors, because they argue, oh, there's multiple distributors, the distributors are automatically liable without proof that they're negligent, without proof that they knew or should have known about it, they're liable if we prove that the consumer consumed that product. So the only issues in the distributor cases are whether or not there's proof of purchase, and that's a relatively small issue, Your Honor. And I will admit it is different because someone purchased from Costco and the carrier plaintiffs purchased from Whole Foods, but that is a really minor issue in my view. So in any event, our argument is these babies should be put back together in the same trial, and I see no justification for doing 3 5 to 6 week trials in a row, one for the first baby Wren, second trial for the next baby carrier, and the third trial for the other babies, and I think Mr. Tagano's in that case also. I mean, it just makes no sense, Your Honor, and it's not an unwieldy number of plaintiffs. I think the total number of plaintiffs is 9 or 10 after a consolidation. The Manual for Complex Litigation says that you can try as many as 14, 18. This is not an unwieldy number, especially when you have, the first 5 babies all pretty much the same. And so for those reasons, we think the case should be consolidated, Your Honor. And, if they want to file a motion, if we get into the discovery process and they think for some reason one or more of the cases can't be prepared or there's some particular issue in those cases that they think is so unique and different that we just can't try it together, they can file a motion for severance at that time. They can file a motion containing the trial date. So you're not making a final decision that, all 10 of these people are going to go to trial. But we're just consolidating them, and we're heading towards that path, I can see, but it's not a final decision. So for that reason, I would submit that we should grant the motion to consolidate. Special Master Hale, I give him kudos. He's done a fantastic job. It's not easy hurting this many cats, but he's been doing it. And, we've got to the point where all the expert reports are filed. The rebuttal reports are filed. Like I already said, we're taking the first expert deposition next week. We're on a track to get them all done by June 7th. So I just don't see a big problem getting this second case prepared because the first case, like I already said, is going to go on July 31st. So I would submit it on that. Thank you.
How will it promote judicial economy?
Oh, well, Judge, it's the same case. So you're going to try, it's like if there were 3 people in a car accident, there's a driver and there's 2 passengers in the back and some drunk driver hits them and they all 3 file separate actions. We're going to try all 3 of those cases. Okay, 5 weeks here, 5 weeks here, 5 weeks there. It's just, I don't see how anyone could possibly argue that it would not promote judicial economy to try these cases together because it's basically the same case, Your Honor. It's just a number of different plaintiffs. So it's really the choices, like I said, the choices between 3 5-week trials and 1 5-week trial.
Thank you. All right, let's hear from, I think this is the order of the oppositions, responses, and joinders. Nevada Beverage, Affinity, United Natural Plus, and then Costco, then a joinder. Can we argue in that order, or did you have a plan to argue it differently?
Your Honor, this is Ichi Life from Nevada Beverage Company. I would defer to the other defendants first and then sort of clean up.
Okay. All right. So.
Thank you, Your Honor. Joel Odou on behalf of Affinity Lifestyles and Real Water. I'll be brief. I think that the court has noted in the oppositions filed by Nevada Beverage and by Costco, there are some charts talking about the different issues that the distributors and retailers have. And so I will defer those arguments to those folks. I would note that it's not a question of doing the depositions between now and next year. We have expert disclosures in the Wren and Carrier case due on August 7th. And so I want to primarily focus our argument on the Cavey case and how it's not proper to consolidate that case. It's the newest case. The discovery hasn't started in that case. We've got allegations of the medical costs. They're about $1.4 million for the 10 plaintiffs in the Cavey case. And I say that because all the cases are serious, and that's not the issue. But the issue is getting the medical records, getting them reviewed by experts, and making that August 7th deadline if this case was consolidated. Layla Cavey, in addition, claims injury from 2018. That's a distinguishing fact for her case, and she's one of the babies. That's a distinguishing fact from her case. From the other cases, she treated at Children's Hospital of Colorado. The other babies treated in Salt Lake. And so there are some differences factually in the Cavey case. And finally, I would just note that while there has been testing done as to some of the products that some of the distributors have, and there have been findings by the FDA, we have not seen testing done in the Cavey case because it just started out. It was filed in January. And for those reasons, we would ask the court, if the court's inclined, to consolidate Carrier and Wren, not consolidate Cavey, because it's so new and it does have substantially different factual issues as far as real water goes. As I noted, I think Nevada Beverage and Costco also have fairly good arguments as to why the Carrier case shouldn't be consolidated because of the charts they provided. And I would defer to them and join in their arguments as to their factual, just at the convenience of the court, and not repeat arguments.
Thank you. All right, United and et al. Okay. United Natural, does somebody need to unmute?
Your Honor, I'm sorry, United Natural Foods, Stephen Spurlock. I would join with Mr. Odou, Your Honor. The only thing I would add, that in the event the court decides to join these cases because of the Cavey case, and it's so new, that the remainder of the dates be pushed out. We can't be held responsible for bringing in a new case with the other two when we got deadlines coming up, and if we're going to join those cases, we need to push the deadlines out, Your Honor, and that's our greatest concern.
Thank you. Costco?
Good morning, Your Honor. Noureddini, Pro Hoc Vice pending on behalf of Costco. Can you hear me all right?
I can. Hang on, you're breaking up now. Get closer to the mic and please speak more quietly, not quietly, slowly.
Is this better?
Yes.
Great. I want to highlight a few points that pertain to, I think, Costco specifically, as well as the distributor or retailer defendants maybe more broadly. But one thing to start off, I wanted to highlight for the court is that, as has been mentioned, CAVA is the most recent of these cases, which was filed this year. Costco was only
January 23rd. Yeah, it was only filed January 23rd.
Costco answered that the CAVA case in late March of 2023. Costco is not the defendant in Wren or Carrier and has not been participating in anything that is specific to discovery in both cases. And Mr. Kemp spent a lot of time today discussing the different plaintiffs in these cases and focusing on the children. And while that is certainly true that there are children in all three of these cases, I think what also bears noting is that there is also adult plaintiffs as well, some of which are the parents of these children who also bring claims on their own behalf, but others who are unrelated to those children and are still bringing claims, which brings the total of plaintiffs to 17. And to highlight the distinction, we did by means of charts, but each different case has a different retailer and distributor defendants, such that there's no. So Costco specifically is the only retailer, along with Speedy Mart in the CAVA case, Whole Foods in their case. Wren doesn't have any retailers or distributors at all. So that bears noting. And Mr. Kemp mentioned in his argument the fact the law pertaining to strict liability. And while strict liability is certainly at issue in these cases, the complaints all allege multiple action. So beyond negligence. So certainly facts beyond and showing proof of purchase or linking it to a retailer or distributor would be required for other causes of action. And then moving into kind of what Your Honor highlighted when asking plaintiff's counsel some questions about efficiency, I don't think that consolidating cases for trial would promote efficiency. first off, the plaintiffs are suggesting that it doesn't matter where the bottle was purchased from, what size it was. That is certainly undisputed fact from the defense point of view, Costco's point of view specifically. There is a distinction as to which size of the bottles were purchased by each plaintiff. In Wren and Carrier, the plaintiffs allege that they purchased 5-gallon jugs of real water. That size of real water was never sold by any of the retailers, including Costco. And so from Costco's perspective, the arguments that it would make are dependent on the type of real water. As Mr. Odou discussed, there are temporal differences between the plaintiffs as well. The Wren and Carrier plaintiffs and the Kava plaintiffs, with the exception of 2, they all have 2020 claimed injuries. When you add in one of the child plaintiff in Kava, she was hospitalized in 2018. So that automatically introduces different outbreaks. The government investigation that was conducted in 2020 would not apply to what was done in 2018, and it just introduces different factual circumstances that do distinguish these cases from one another. And in terms of the trial length, I think it's important to realize that if these cases were not consolidated, Costco, for example, would have no reason to be participating or sitting through a trial in Wren or Carrier. It would not have any reason to present its witnesses. It would have that doesn't save any time. And the same goes for the other retailers and distributors. Because there isn't any overlap, if the cases weren't consolidated for purposes of trial, the witnesses for each of those cases and the defenses that the defendants would put on their own behalf would not need to occur but for consolidation. And apart from that, each of these plaintiffs, while there is some overlap in terms of the child plaintiffs and their treatment, just by the language of the plaintiff's own initial disclosures, that is certainly not identical. There's a lot of distributors and providers that do not amongst these plaintiffs, and certainly amongst the adult plaintiffs. To the extent that there is overlap, each physician would still have to lay and explain the injuries and treatment that are particular to that specific plaintiff, even if the same provider treated more than one plaintiff. And then lastly, which I think is actually one of the most important points, I think the prejudice that was not be ignored. If we put together 17 different plaintiffs, when only a handful are making allegations against Costco, I'll focus on Costco as that's my client, risk the jury lumping together these defendants where they shouldn't be and attributing the conduct of one defendant to another. So I think it has a lot of potential to cause juror confusion and to perhaps jurors assume, just by the fact that there is a lot of different plaintiffs making the same or similar allegations, that there is something that sheds to the claim. And we've cited various case law and authorities that show that the consolidating cases in this way and increasing the number of plaintiffs has a tendency to cause that kind of response in jurors and to increase damages. And I think that's especially problematic when you consider that punitive damages are at issue here. So it's especially important for jurors to only attribute fault for a defendant that is being alleged, that is having punitive damages alleged against it, to only attribute the fault conduct of that defendant when deciding whether punitive damages are appropriate. But when you consolidate all these matters and have it all tried together, I think you risk error in that regard. And so with that, I would respectfully request that the court deny the plaintiff's motion. And if Your Honor has any other questions, I'm happy to address them.
Thank you. All right, so Mr. Lyle, if you'll do your opposition along with your joinder.
Your Honor, I have nothing further to add. I'll just join into the arguments that Costco have already explained.
Good enough. Anything else?
Yeah, Your Honor, in Speedy Mart.
For the record, your name, please.
Oh, I'm sorry, John R. for Speedy Mart. We also filed a joinder. And I would just like to.
I guess I missed that, sorry.
I was told that it was filed in Department 27 and courtesy copies were sent over to, I'm sorry, Department 31 and courtesy copies were sent over to Department 27.
Go ahead and do your joinder.
Thank you. So I'd just like to echo and add to the arguments made by Costco's counsel. I think plaintiffs gave short shrift of prejudice here. Because Speedy Mart's in a similar position as Costco. This is a very new case, and 80 gigabytes of data were just dumped on our office. That we now have to go through. Obviously, we even haven't had an early case conference yet in this case. So to suggest that we can just quickly retain experts and mine through all of this data and figure out what specifically relates to Layla Kadeh, I think just the mountain that puts in front of the defendant, the retailer defendants especially, it's insurmountable at this point. I think to consolidate these and kind of fast track us to a trial that we just can't reasonably be prepared for.
Thank you. Did anyone else want a chance to do an oral opposition?
Your Honor,
this is Scott Rasmussen. I don't know if you can hear me or not. I represent in the Kaveh matter and just filed my answer on May 3rd, 2023. So I was unable to, under the timelines for oppositions and joinders, to file something with the court. We would like to make an oral joinder to everything that has been said here. My particular company client that I have in the Kaveh matter only would be prejudiced significantly in this case for a 2018 timeline as to when the Kaveh plaintiffs are suggesting that they were injured in these matters. The way that things were done by my client and other things was not the same as it was at the time that the other plaintiffs in this matter did things. We are a measuring company. We do scientific instruments and we measure things, but we don't test things, and we're not. The way things were done there, the models that were used of our measuring device was different and things like that. We would have to have 3 or 4 different items up in front of the court and the jury to try to distinguish between all of these things at that time. And I think based on the fact that we are being brought in right this month to consolidate that case in all of this, I think is very prejudicial at this point with the amount of stuff that we need to be able to do and try to get that all consolidated with deadlines that are in August. I think is very prejudicial to my client for a different time frame than the other cases. And I know I'm echoing a lot of what's already been said, but I hope the court understands the arguments as to why I believe it's very prejudicial and the difference in evidence that will be needed to be brought forward at that time. Thank you.
Thank you. Other oral argument?
Your Honor, good morning. This is Jonathan Fountain on behalf of defendant NSF International. NSF has very recently been named as a defendant in 7 of the real water cases. The Cava case is one of them. NSF is not named in Wren or Carrier. NSF appeared in the Cava case on March 31, just very recently when it filed its pending motion to dismiss. Plaintiff's motion to consolidate was filed in this case the next day on March 22nd, but it wasn't separately filed in the Cava case, so we didn't get timely notice of this motion. And as a result, we've not filed an opposition to the motion, but NSF does join in the arguments today that have been made by Costco. And if I could, I'd just like to take just a second to tell you a little bit about NSF. NSF was retained by Real Water to conduct a facility audit because Costco required its vendors to do that. And from 2014 to 2018, Real Water contracted with NSF to perform annual 1-day facility audits of the Real Water facility. This is not a product audit and did not involve testing any of the water. Real Water failed its December 2018 facility audit under the Costco criteria that NSF was provided with. And under the guidelines, a re-audit had to occur. NSF performed a re-audit, and because Real Water had addressed the issues from the first audit, Real Water got a passing score. That's Costco's involvement in a nutshell, and Costco has motions to dismiss pending in, I think, 5 of these cases right now. Excuse me, NSF has a motion to dismiss pending in 5 of these cases right now, based on it being a third-party auditor and really too far down the causal chain for it to be a proper defendant in these cases. But NSF does share Costco's concerns about the Cava case being in its very infancy, and Wren and Carrier being so much farther along in discovery and having to rush along and try and do all this discovery to be ready for trial. We also share the concern about a large number of different plaintiffs and defendants across the 3 cases, as well as the disparate facts and circumstances appear to predominate over common ones. And so we certainly share Costco's concerns about juror confusion and the viability of any judgment here. Thank you.
Any other comments before I hear the reply in support of the motion? Mr. Kemp.
Your Honor, first of all, I heard nothing on judicial economy. Nothing was said whatsoever by any of the defense attorneys as to this case, that they wouldn't promote judicial economy to do 1 trial instead of 3.
I heard a lot about prejudice, though.
I heard a lot about prejudice, and let me get right to that. Mr. Rasmussen claimed that there's something different about 2018 that he needs new discovery on. Well, he's not telling the court that in the Gallagher case, one of the plaintiffs is a 2018 plaintiff, Mr. Haley. So, you know, this argument that 2018 is somehow different as to Hanna Instruments, you know, he's filed expert reports on this in the Gallagher case, including the 2018 claim by Mr. Haley. So there's nothing that happened in 2018 that I know of concerning Hanna that requires more discovery. And I was surprised to hear him say that. And then, you know, they say, oh, well, we can't try cases for multiple years. The Gallagher case, we have Mr. Haley, a 2018 consumer. We have 2 people, the Gallaghers and Mr. Belsky, 2019 consumers. So half of the people in that case are not 2020 consumers. The other 4, almost half, the other 4 are 2020 consumers. So this temporal thing just doesn't make any sense, Your Honor, for this reason. It was the same concentrate, the same secret formula that was made by the exact same people, Blaine Jones, in the exact same room, the concentrate room. That concentrate was put into all the bottles, the 5-gallon bottles, the 1-liter bottle, the 1.5-liter bottle. Every single bottle got the same concentrate. There were not 2 concentrate rooms, one for 5-gallon bottles or 5-gallon jugs and one for the retail bottles. There was 1 concentrate room. They would make the concentrate, and I could get into detail, but I don't think it would help the argument. But they make the concentrate, and then they put the concentrate into a big, is it 200-gallon or 300-gallon? 300-gallon, and then they store the concentrate, okay? They make the batches once every couple months, but then that concentrate is used when they're making both lines of water, the 5-gallon and the other one. So there's no difference whatsoever whether you're in 2018, beginning of 2018, end of 2018, early 2019, late 2019, 2020, same concentrate. And they testified that they made it the same way. So that's what the FDA tested. That's where they found the hydrazine. After that, they tested some retail bottles and they found even more hydrazine. But this temporal thing has no merit. Second argument, Costco can't get ready. Well, counsel conveniently omitted the fact that I have already taken the deposition of the primary Costco person. I took the deposition already. We took it 2 months ago. I have one more Costco deposition I've asked for, and then I'm done with Costco discovery, Your Honor. So Costco, clearly we can prepare that case. And they say, oh, we don't have medical records. That is just flat out not true, Your Honor. They got medical records when they got the fact sheets. So with the exception of Mr. Morales, they have the medical records for everybody. I think I've already addressed the different bottle size argument. in, you know, the Quebec case, they I don't see what the difference is that the baby went to Colorado as opposed to the baby went to Salt Lake City. Because the only issue in the case is, one, did the babies drink real water? Okay, that's the proof of consumption issue. And two, what caused the injury? Are there alternative causes? These baby cases, they're not like the adult cases. In the adult cases, they argue everything under the sun was the cause of liver damage. Like I said, they're drinkers, you know. They used some kind of supplement, or they took turmeric, or they lived in a bad area town that had arsenic. You know, they've got all kinds of excuses for the adults. All right. The babies, they have no excuse for it. You know, they can't say the baby was smoking. They can't say the baby was drinking. Right. So the baby causation is a real simple issue on all the baby cases. And, you know, and I think, you know, counsel forgets to point out that in the Gallagher case, real water, the epidemiologist has basically conceded liability. Their epidemiologist, Dr. Goldsmith, said that there's no other explanation other than the hydrazine in the concentrate. So now they come to court and say, oh, Judge, there's so many different issues. We got to do this, that, and the other thing. But they have basically conceded liability. And I think we cited Dr. Goldsmith's testimony in the reply. You know, in the timing of discovery for all cases. Okay. 10 plaintiffs. The depositions have lasted between 1.5 and 2 hours. We can't do that discovery in the next couple months. I mean, that's pretty simple discovery in my view. The experts, as I've already pointed out of the 30 experts approximately 30 that have been designated for the Gallagher case, it's expected that the parties will reuse all the liability experts and they won't have to be deposed again. So we're basically stuck with 2 causation experts on plaintiff's side and 5 theirs. I think there's plenty of time to depose those experts. But I'm not asking the court to make a final decision on this. If they come in and they say, oh, Judge, we just had this extraordinary problem with one of the cases, you know, the doctor from Colorado went to a coma. We couldn't take his deposition on the Quebec case. Argue a severance. They can argue a severance. But that doesn't detract from the main factor that it promotes judicial economy. There's clearly common questions of issues in these cases because same concentrate, same plan, same testing, you know, it's all the same. There's clearly common questions of law in these cases. And for those reasons, one second, Ryan. Okay. Yeah, and I point out that we provide all the information. The carrier plaintiffs also provide all the information. Theirs was provided so long ago, no one's even arguing about it. So for those reasons, we think that, you know, they seem to be endorsing a partial consolidation. Put the 2 babies together, the Wren and carrier babies, but keep all the other babies out of this trial. I don't see the sense of that. You got 5 babies, the exact same 24-day time period, went to the same hospital. How does it not promote judicial economy to try the case together? And so for those reasons, Your Honor, we'd ask you to grant the motion to consolidate.
Now, I'm really troubled about the age of the Quebec case, and that's the problem I'm having. I can grant the motion with regard to Wren and Carrier, but Quebec to bring in 10 new plaintiffs with no discovery. The complaint in Wren goes back to March of 2021. The Quebec case wasn't filed until January 23rd of this year. So grant the motion in part. I do find with regard to Wren and Carrier common questions of fact and law, that there's no prejudice because discovery's been done there. They promote judicial economy. There's an overlap of witnesses. You know, and I was a little concerned about the different distributors, but that makes sense. I'm going to deny the motion with regard to Quebec, even though it is also a baby, only because I don't think it's fair for the defendants. They have to be ready for trial. They haven't even filed answers.
Judge, assuming we could get the discovery cleaned up a little bit, not without prejudice.
Without prejudice.
Okay, thank you.
All right. Your Honor, if I may, one of the points that was made with regard to the timing of the trial coming up with Wren. One of the things that Mr. Kemp has pointed out, in the next 30 days, we are taking 28 depositions of experts. And by having to take those depositions of these experts and the other issues that we have with regard to the trial, by by having the Wren trial scheduled as it is, it's going to create problems, and we're going to be back here in front of this court.
You know, and it's May, you don't have a calendar call until January. And as I always say to everyone, we will find a way to get your case tried in a way that's most fair to everyone.
Thank you, Your Honor.
And so you'll prepare the order, Mr. Kemp, and your team.
Yes, Your Honor.
Anyone who wants to sign off on approval of a simple form of order, indicate on the record, please, and try to do it in the way you made your appearances.
Joel Odou for Real Water. We'll sign off.
Okay, so Mr. Odou, how about United Natural, Nevada Beverage, and Costco? Anyone else? I think Mr. Rasmussen also spoke.
Yes, that would be for SID US Inc.
All right. Anything else to take up today? No.
No, Your
Thank
Honor.
you all for your professional courtesy.
Thank you, Your Honor.
Thank you, Honor.